Welcome to Law and Society. Today I'm going to go over the Supreme Court's oral arguments in the obstruction case, Fisher versus United States, where one of the January 6th defendants has, the district court ruled that the obstruction statute applied by the prosecutors do not apply to obstruction as it refers to in the January 6th riot context. The appellate court reversed it, saying that the obstruction statute does apply, and now the Supreme Court is hearing the case. It is an obstruction statute under 18 USC section 1512, subsection C, and subsections 1 and 2. So what I'm going to first do is read you the statute in question. And then what I'm going to do is do a brief overview of the oral arguments that the Supreme Court had in this case. This case has a big impact on January 6th defendants, because about 300 plus January 6th defendants have been charged with this statute, 1512C, so 18 USC 1512C. So the court's ruling and Donald Trump also has been charged under this statute. So the facts differ between Mr. Fisher, who assaulted the police officers, was in the front line, had the intent of going and delaying and impairing the proceedings and obstructing the proceedings. So Donald's set of facts for obstruction is different. And so let me read the statute to you first. First of all, thank you for being here. If you're new to my channel, please like and subscribe, and let's get to it. 1512, Section C says, whoever corruptly alters, destroys, mutilates, or conceals a record, document, or other object, or attempts to do so with the intent to impair the object's integrity or availability for use at an official proceeding, or otherwise obstructs, influences, or being number two, or otherwise obstructs, influences, or impedes any official proceeding or attempts to do so, shall be fined under this title or imprisoned not more than 20 years or both. So obviously C1 doesn't apply here, but C2 is a catch-all provision for obstruction. And that is what the government contends, whereas Mr. Fisher's attorneys contend that Enron era evidence tampering obstruction statute, as this 1512 statute is, does not apply to Fisher. Two sections of 1512 are to be read together and is about evidence impairment, and it's not an obstruction statute, or general obstruction statute. So the court then goes into talking about the history about C2 filling the gap and being the backstop provision when the government's attorney comes up. It was a deliberate attempt to stop. So when the government's attorney comes up, she points out that what happened was a deliberate attempt to stop Congress's official work during certification. And it is a straightforward question under the obstruction statute in 1512 C2. And that C2 is a separate provision from C1. It is related to C1 as in the context of being official proceeding, and it is connected by saying that it is the catch-all, otherwise obstructs, influence, or impedes, meaning catch-all for any other conduct that is not in C1. And so there's nothing in the statute that says it's not a generally applicable obstruction statute. Then the court and the attorneys get in the government's attorney gets into the question about what is obstruction. To what level of obstruction would qualify under 1512C2, and government's attorney says that it has to obstruct on its face, meaning a meaningful obstruction, not a de minimis delay. And there was a hypothetical thrown out by Justice Alito that talked about what if people came into the court proceedings as they were having court proceedings and protested, and people had to be removed. Then the context would depend, the government says. And when pushed to say that, yes, take into consideration that they did have the requisite intent, and they corruptly came in and they wanted to stop the proceedings, and then the government says, should at that time it can be proven that the people who broke into the Supreme Court proceedings had the intent to delay, obstruct, influence, or impede that official proceeding, then it would qualify under this statute. So what the government has to prove, and the government's attorney says here, is that stringent mens rea, meaning criminal intent. You have to prove that he knew of an official proceeding, specifically intended to stop the proceedings, and the consciousness of wrongdoing, the preparation of violence, and the nexus to the proceedings. A nexus to the proceedings being relationship in time to the proceedings. And those are the elements that the DOJ has to go to and see if a defendant qualifies under those in order to be charged under this obstruction statute. Government's attorney says that out of the 1,300 plus people who have been arrested because of January 6th, only about 300 have been charged under this statute because of the stringent mens rea that is required. Government says that C2 includes myriad ways of obstructing. That specific people had in mind specific proceedings, intent to obstruct, and nexus from the proceedings. It covers a full range of obstructive conduct, and the breadth of the statute is not overbroad because of the actus reus of obstructing that is required. That is not just a de minimis requirement of obstruction, but an actual obstruction that has happened in this case, where they came in with the intent and the preparedness to stop Congress's certification of the 2020 election. So the Supreme Court had some concerns about sentencing guidelines and how other obstruction provisions in 1512 have lower punishments than 20 years or both. And to that, the government says that typically the sentencing guidelines in these cases have been for people, generally for everybody, if they have not had a criminal conviction, is average of 10 to 16 months. And in cases, about 50 people who have been charged in this obstruction statute have been sentenced to about 26 months or 2 years, a little bit over 2 years, which is a far out cry from the maximum that is allowed under this statute. So the idea that the sentencing guideline for Mr. Fisher would be 20 years is outlandish to comprehend. So that is what this is about. The court has to decide whether 18 USC 1512 Section C2 is a catch-all obstruction provision that includes anybody who otherwise obstructs, influences, or impedes an official proceeding or attempts to do so, independent of altering, destroying, mutilating, or concealing record, document, or other object, or attempting to do so. All of it making it unavailable for the official proceedings. So the petitioner here, Mr. Fisher's argument is that it's a evidence tampering statute that is not a general obstruction statute, and it doesn't apply to Mr. Fisher's case. And whereas the government says that C2 is a catch-all obstruction provision that has been used before for obstruction cases, may not be exactly in this context. So the question for the Supreme Court is whether Mr. Fisher, and along with him the 300 plus defendants, criminal defendants from January 6th, who have been charged and are under 1512, if they meet the stringent requirements of as presented by the government, and whether C2 does in fact apply broadly to obstruction. So it's a kind of, I haven't followed this case. I've looked at, I read the, I read the statute, but I didn't read the briefs of this case. I just heard the oral arguments, because the oral arguments are, sort of condenses the whole thing. And, with January 6th, it's really hard to keep up with everything. So many people said that the court is inclined to go against the government. I didn't see any such inclination. Again, my prediction with the disqualification was hopeful, and I was wrong. With this, I'll be a little bit more realistic. Section C2 is clearly a catch-all obstruction provision that says otherwise obstructs, influences, or impedes any official proceeding. So there's no constraint on it being about evidence tampering, or it being, specifically an Enron era sort of evidence tampering statute that is not generally applicable to obstruction of official proceedings. When the statute itself says any official proceeding obstructs, influences, or impedes any official proceedings. And when they knew of the official proceedings, specifically intended to stop them, was conscious of the wrongdoing and prepared for the violence, and were in the nexus of the proceeding in relation to time of the proceeding, they all indicate towards obstruction of an official proceeding, which 1512C2 does incriminate. So with that said, if you have any questions about this, I don't know many answers other than what the Supreme Court is going to say. This could have a huge impact on the charging documents, because it will shave off some time off of the defendants, because many of them have been charged with other crimes as well. This is the only one that has been brought up to SCOTUS and has reached the standard of being discussed by SCOTUS. So let's see what SCOTUS does. Hopefully upholds the law and says that this obstruction statute does cover January 6th rioters, because it was a conscious decision on their parts to go out and obstruct in a meaningful way and stop the proceedings from happening, because they knew the nature of the proceedings and they specifically intended to do it. And they went and assaulted police officers, and that cannot go unanswered. And the whole point of that was Donald Trump telling them to go to the Capitol and stop the steal. Remember, he was telling them to stop the steal. And they did, for several hours, stop the steal. The insurrection went on for 3 hours and 17 minutes, and then another few hours went by before Congress could reconvene for the certification process. So, with that said, I don't see any questions because I'm doing this in the middle of the night. And I'm also hurrying up because I've been having power outages in this part of the world because it's extremely hot and everyone's turning on their air conditioning. So, with that said, thank you. Thank you for being here. Thank you for listening. And thank you to Deb for making it possible for me to get new air conditioning so I could come out to you and talk to you about this case. Take care.